Yes, so this is part 2. Some of you may have attended part 1 on children who are subject to an adoption order. So this session we're going to be looking at children on an SGO or child arrangement order. So I'm Ellie Bissell and I'm the Education and Support Officer for previously looked after children with Surrey Virtual School. So we're going to start with Catherine, who's going from the Friends and Family team, who's going to talk a little bit about SGOs and child arrangement orders. And then I'm going to talk a little bit about the virtual school and our role in supporting this cohort of children. Before I start, just a little bit of housekeeping. We'll go to the next slide. So you'll notice that your cameras and microphones are muted for the presentation because this session is being recorded, but we will take them off of mute after the session so we can answer any questions or queries you might have. During the session, if you do have a question, please pop it in the chat and we will try and answer it, or we may leave it until the end if it's something a bit needs a bit more unpicking. The session is running until 5:15, although it may end a little bit earlier. After the session, I will put the link to the evaluation questionnaire in the chat. If you could fill that out, that would be really, really helpful to understand how you found the session, if it was helpful, and also if there's any future training that you would like for us to put on. And then also you will receive an email in the next coming days with the presentation slides and any other resources. So I'm going to hand over to Catherine, who is going to talk a little bit about SGOs and child arrangement orders.
Lovely, thanks, Ellie. So I'm Catherine Tusher. Good afternoon, everyone. I'll be speaking mainly about special guardianship orders. That's my bread and butter, but also because there's a lot more to be said about them in light of the legislation making much greater provision for what comes with a special guardianship order than with care arrangements order. So just a bit about me. I'm situated within the Family and Friends team. I'm based at Quadrant Court in Woking. We have an East Family and Friends team base over in Red Hill at Consort House. I've been a qualified social worker for 27 years. 18 of those have been with Surrey Children's Services, about 16 of them with Surrey Children's Services, and the last 4 with the Family and Friends team, which is situated within corporate parenting or the fostering service. In about 2013, the Family and Friends team was established, as I said, within the Corporate Parenting Directorate, and the remit of the Family and Friends team is twofold: to complete special guardianship assessments for children subject to care proceedings and or who are looked after, and oversee connected persons foster carers. So those are a family, a relative, a friend who's approved as a temporary or a permanent foster carer. So in early 2019, the post-order support lead was established. I'd been banging on about there needing to be a more proactive approach to post-order support, bearing in mind that there are provisions within the SGO regulations for what every local authority should be providing. And in my opinion, Surrey was falling short. And it's been easy for local authorities to fall short because it's not an area that Ofsted looks at least not yet, but I think that's coming, which will be a good thing. And also in 2019, we had a new regime of management that came into place following the large reorganisation that Children's Services and much of Surrey County Council went through in 2019. And the new management regime has a greater level of commitment to post-order support. So in addition to establishing a lead, late 2019, I have a second support that works alongside me, a social worker who is appointed to work alongside me. So the two of us deliver post-order support. So just a bit about what is special guardianship order, thinking about its scope and limits. So it came into force under the Adoption and Children Act in 2002. The statutory post-order duties are outlined in legislation, specifically the SGO regulations of 2005 and the SGO amendment regulations of 2016. So the special guardianship order is intended to meet the needs of children who cannot live with their parents, however, can still thrive within a secure legal placement. So special guardianship order provides stronger permanence than a care arrangements order or a residence order. So special guardianship order is a permanent order appointing one or more individuals for a child's minority. It's a bit of a middle ground between adoption and fostering, allowing children to stay connected with their family of origin, thus retaining their sense of identity, and a bit of a halfway house between a care arrangements order and adoption order. So Children's Services steps out after the child transitions into the special guardian's care. The intention of special guardianship is that it enables the hand of the local authority to fall away, unlike when a child is looked after, when there's quite a high level of local authority involvement that continues for the duration of the period of being looked after. By and large, Children's Services steps out so that the child and family can get on with their life together. So Surrey Children's Services started actively implementing the special guardianship pathway in care planning and public law care proceedings in about 2006-07. And the vast majority of the orders were made after 2010. An estimated 570 to 600 SGOs have been granted by the Surrey Family Court since 2006. Before granting a special guardianship order, the court must consider a local authority prepared SGO report. So what that means is there's a very in-depth assessment taking into account the personal background, including a full understanding of the childhood of the SGO applicant, full medical history, including GP records, independent references and interviews with those referees, enhanced DBS check looking at the financial stability of the individual, alongside, of course, a robust evaluation of the prospective special guardian's ability to understand and meet the child's current and anticipated developmental needs. So including consistent prioritization of the child's needs over those of the parent in both the short and the long term. There's a minimum of 12 weeks that is allocated for an assessment, and an average assessment report can be easily 60 pages in length. So as I said, it's a very comprehensive assessment.
Sorry, Catherine. George, I think we're on the wrong slide.
Yeah. Sorry, I'm looking at my notes, so I'm not seeing what you are. Okay, right, so we've gone through who I am. There you go. Next one, George, please. Right, so we've gone through scope and limits. You all will be receiving the slides on email, so you'll be able to take a closer look. Okay, and carry on to the next one, please, George. Right, here we are. So the SGO naturally expires on the child's 18th birthday. So it can only be terminated before the child turns 18 by way of a legal process. So that might mean, well, does need to mean a court application that is filed to discharge the special guardianship order, and that can be filed by the special guardian themselves, a birth parent, or the local authority. And it does need to be filed with the authority in which the order was granted. So changing the named special guardian to a different person, for instance, if the named special guardian were wished to resign, or adding a new special guardian alongside the existing named special guardian does require court approval, and there would need to be a full SGO assessment if they were looking to add another special guardian. So it's not as simple as just a paper exercise and quickly done and dusted. It does need to go through that legal process. Thanks, George. So thinking about parental responsibility, or PR, and the implications for those, particularly for the birth parent under special guardianship. So the SGO limits the rights of birth parents to intervene or challenge the order without leave of the court. The special guardian shares parental responsibility with the birth parents. However, the parental responsibility of the special guardian is dominant. The special guardian has the legal authority to make all decisions, excluding the birth parents from their knowledge or consent. And this is quite distinctly different from a care arrangements order where parental responsibility is shared 50-50. There are only 3 instances where a special guardian must obtain written parental consent or seek leave of the court in the absence of parental consent. And those include 1, removing the child from the jurisdiction for a time longer than 3 months, so over 3 months. So up to 3 months, for instance, an extended holiday, the special guardian does not need to obtain parental consent, nor does the special guardian need to even inform the parents of the travel plans or whatever the family will be doing for anything that lasts under 3 months outside of the jurisdiction. The second instance of requiring parental agreement or leave of the court would be if the special guardian were to seek to legally change the surname of the SGO child. And then lastly, if the special guardian wished to seek to adopt the SGO child. And their instances of this would be very, very rare. And that's because the parental responsibility, the weight of that responsibility that comes with the special guardianship order really precludes the need for an even more serious order in the form of adoption order, where the parents lose their PR entirely, because under special guardianship, all day-to-day decision making, big and small decisions, are the domain of the special guardian, and they do not need to inform or make joint decisions with the parent. Now, that doesn't mean that they can't do that. Of course, if they wanted to and felt that that was appropriate, then that's their decision to take. They have the autonomy and the authority to take all of those decisions, how they want to conduct all care for the child, to the exclusion of the parent's consent or inclusion of the parent involvement. Next slide, please. Thank you. So if a birth parent is dissatisfied about the special guardian's decisions or caregiving, for instance, if a parent weren't happy about the parent-child contact arrangements or a school choice, etc., a parent can seek formal or informal mediation, or could, of course, instruct a solicitor with a view to resolving the matters outside the court arena. Where matters are not successfully resolved outside of court, or if the parent does not wish to engage in negotiations or mediation, then the parent can seek court adjudication by making an application to the court. And parents do not need legal representation in order to make an application to seek court intervention or adjudication. But the court's strong preference is for parties to make an earnest attempt to resolve differences outside of the court arena, utilising the resources available. So mediation being one of them, the Surrey Family Mediation Service, and then we provide informal mediation within the family and friends team. And if there were circumstances that were of a safeguarding nature, then it may mean that it would be children's services who would be looking to provide that intervention to make decisions about contact, parent-child contact. The next slide, please, George. Thank you. So the birth parent can seek to discharge a special guardianship order through a court process. So this is a very complex process, and that's if the court agrees to accept the application for SGO discharge. So the court rarely rules to permit the discharge proceedings, and often a parent's application is denied. Oops, sorry, I can't see. Hang on. Bounce back to my slides here. So the application is often denied at the preliminary hearing, and the court also has the remit to stipulate a timescale before which the parent would be able to lodge a further discharge application. So next slide, please. So thinking about the pathway to SGO, and I just wanted to spend a little bit of time explaining this because it does correlate to how post-order support is delivered. So just really to summarise, there is either a public law or private law route to special guardianship. So the majority of special guardianship orders arise from Children's Services' long-standing safeguarding intervention or a non-accidental injury. So, for instance, the local authority instigates care proceedings, which is ostensibly the state taking the parents to court for child permanency decisions to be made in the court arena. During the proceedings, the child either remains in parental care or becomes looked after under Section 20 voluntary accommodation or under an interim care order. The Children Act of 1989 requires local authorities to consider the care of the child within the wider family and connected persons. So birth parents are invited to propose a relative or a friend for short-term fostering approval, known as a Regulation 24 emergency fostering assessments. And long-term care needs to be considered as part of the contingency or parallel planning in the event the court rules permanent removal from parental care at the final hearing. So in this instance, the SGO assessment is completed by the family and friends team. So another occasion in which SGOs are made is where parents voluntarily under Section 20 accommodate the child. So they become looked after, and this may very well preempt the need for care proceedings to be instigated by the local authority or may occur within care proceedings. The parents are invited to propose a connected person to be assessed as a temporary foster carer. There's a Regulation 24 emergency assessment undertaken of the relative or friend, which is the connected person, and then subject to the Regulation 24 assessment, the child will become looked after, and a more comprehensive SGO assessment would be undertaken and completed by the family and friends team. Next slide, please. So some special guardianship orders arise during Children's Services involvement, but where there are no care proceedings or fostering. So under the auspices of a child in need or child protection or public law outline plan, Children's Services endorses a family member, a friend, a connected person. Connected person is the language that's used in the placement regulations, and so hence my using it here. So the connected person is endorsed and for the child's permanency, and the parents agree to that plan, and it therefore preempts the need for care proceedings or Section 20 accommodation. The connected person lodges a private law application, so they can privately submit an application to the court seeking a special guardianship order. And the special guardianship assessment is completed by Children's Services, not the family and friends team. And then lastly, some, but very few special guardianship orders originate external to Children's Services involvement. So for instance, the parents may wish to legally formalize a private family agreed permanent care arrangement, perhaps if there's parental terminal illness involved. And then the nominated carer lodges a private SGO application. The court notifies the local authority that the application is being made. The local authority assesses, and that SGO assessment is completed by Children's Services. So next slide, please. So just wanted to spend a bit of time thinking about some of the needs of children under special guardianship, particularly in relation to their emotional and behavioural and wider development. The disproportionate number of special SGO children have experienced significant and enduring parental maltreatment, neglect, abuse in pre-birth and or in early childhood, thus significantly impacting on their development and functioning, and that's really all areas of their functioning. So they experience long-term sort of damage, with inverted commas, similar to adopted and looked after children, or some of the difficulties that are often associated with adopted and looked after children. Some professionals and families have a misperception that when a child is placed under special guardianship with a family or friend, that perhaps the safeguarding concerns or the damage to the child isn't as significant as if a child were to be adopted or looked after, that that the family is the preferred option because the scenario isn't sort of as bad. And that's a misnomer, because the reason for having been placed within the wider family is because that's the preference in terms of what the Children Act and all legislation prompts both the legal framework and the local authorities to look towards as the preferred alternative for children, where possible, to be raised within their wider family or friendship network, their connected persons network, as an alternative to adoption or being looked after, and only where adoption and only where special guardianship is not a viable option, whereby there has not been a connected person with a successful assessment, that then the other alternatives are considered by way of the child being adopted, or where a full care order is made and the child is looked after by the local authority in the longer term. So there's considerable neuroscientific evidence through brain imaging and scans of maltreated children that shows significant deleterious differences to their development, their neural pathway development and synapses or connections in the brain. There's a shortfall for them. Many people aren't aware, but the vast majority of neural connections in a healthy child occur very early in life, in fact, before the age of 3. But we don't see that in children who have experienced maltreatment pre-birth and in early life. So we know that insecure attachment often leads to a child having attachment difficulties. I think probably most people attending this are familiar with attachment theory by John Bowlby in the 1960s, and then very famous work that he did jointly with Mary Ainsworth around attachment. And sort of very simply put, the premise or the nub of attachment theory is that the parent or primary caregiver is a secure base from which baby explores the world around him or herself. And that things go wrong for baby's attachment. Sorry, I see a typo there. That should be baby apostrophe S, baby's attachment, if the parent or primary caregiver is not a consistent, responsive, and empathic secure base. The next slide, please. So attachment is characterized by specific behaviors in the baby, such as seeking proximity to their attachment figure when upset or threatened. And of course, secure attachment is prevented if the parent is the one who is the persistent threat to the child through abuse and/or neglect. So attachment behavior in adults towards the baby includes responding to cues sensitively and consistently. So the 4 main attachment styles develop depending upon whether the child's primary caregiver is a secure base who is consistently attuned to and meeting the child's needs. So broadly, the 4 domains of the attachment styles are secure, avoidant, insecure, anxious, and insecure, disorganized. You're probably familiar with post-traumatic stress disorder. Sort of by definition, this does not entirely capture the pervasive developmental impairments that characterize children with early life trauma, as most SGO children have, such as the impaired capacity for emotional and behavioral regulation and attachment-related difficulties. So Bessel van der Kolk is a clinician, researcher, and professor in post-traumatic stress. Some of you may have heard of him, but he's considered one of the most foremost experts on childhood trauma, particularly traumatic life events occurring during the critical and sensitive developmental periods of the lifespan. And his work integrates developmental, neurobiological, psychodynamic, and interpersonal aspects of the impact of trauma and its treatment. And he is significant because in 2005, he introduced developmental trauma disorder, referred to as DDT, as a clinical disorder that captured the spectrum of existing discrete disorders like post-traumatic stress disorder, attachment disorder, that fell short in their clinical diagnostic criteria and fell short in capturing what we see in the presentation of children who have experienced prolonged and enduring maltreatment in parental caregiving. So DDT captures the spectrum of coherent, as I just said, the spectrum of coherent symptoms of children exposed to interpersonal violence and disruptions in caregiving, and the broad domains of impairment and distress that characterize these children and adolescents. Next slide, please. So I'll spend a little bit of time, if you will, just going through the Ddt criteria in diagnosis. And I just wanted to mention this because I think many of you will probably encounter SGO children displaying many of these and in your observations of them. And if and when you do, it would be indicative of the child being in need of it and certainly benefiting from some therapeutic intervention. So the Criterion Diagnosis is manifold. So A would be exposure. The child has experienced or witnessed multiple or prolonged adverse events over a period of at least 1 year. That would be direct experience or witnessing repeated and severe episodes of interpersonal violence and significant disruptions in protective caregiving and repeated changes of primary caregiver, because that includes separation from primary caregiver, having to form hopefully a new attachment to a new primary caregiver, and then perhaps more separations or disruptions of attachment, and that can lead to significant difficulties for the child forming a secure attachment style. So next slide, please, George. So then B would in the criteria would be effective and oh, sorry. Can we move on to the next slide, please? Thank you very much. The effective and physiological dysregulation. So the child exhibits impaired normative developmental competencies related to arousal regulation, including at least 2 of the following: inability to modulate, tolerate, or recover from extreme affect states, so recover from fear, anger, shame, including prolonged and extreme tantrums or immobilization. B2, disturbances in regulation and bodily functions, for instance, persistent disturbances in sleeping, eating, and elimination, overreactivity or underreactivity to touch and sounds, and disorganization during routine transitions. B3, diminished awareness and dissociation of sensations, emotions, and bodily states. And lastly, impaired capacity to describe their emotions or bodily states. Next slide, please. C in the criteria would be attentional and behavioral dysregulation. So the child exhibits impaired normative developmental competencies related to sustained attention, learning, or coping with stress, including at least 3 of the following: preoccupation with threat or impaired capacity to perceive threat, including misreading of safety and danger cues; impaired capacity for self-protection, including extreme risk-taking or thrill-seeking behaviors; maladaptive attempts at self-soothing, so for instance, rocking or other rhythmic movements; and compulsive masturbation. C4 would be habitual, so intentional or automatic or reactive self-harm. And lastly, inability to initiate or sustain goal-directed behaviors. Next slide, please. Okay, so self and relational dysregulation. So the child exhibits impaired normative developmental competencies in their sense of personal identity and involvement in relationships. So this would mean at least 3 of the following would be occurring: intense preoccupation with safety of the caregiver or other loved ones, including precocious caregiving or difficulty tolerating reunion with them after separation. I was talking to a special guardian today and a teacher last week about a child that absolutely cannot remain focused in the classroom setting because they are so obsessively preoccupied about the safety of their primary caregiver under special guardianship, who is their grandmother, about how their grandmother is doing and what she's doing all day long. It's obsessive preoccupation. So D2 would be persistent negative sense of self, including a high degree of self-loathing, helplessness, a sense of worthlessness, ineffectiveness, or defectiveness. Next, D3, extreme and persistent distrust, defiance, or lack of reciprocal behavior in close relationships with adults or peers. D4, reactive physical or verbal aggression towards peers, caregiver, or other adults. D5, inappropriate, excessive, or promiscuous attempts to get intimate contact, including but not limited to sexual or physical intimacy, or excessive reliance on peers or adults for safety and reassurance. And lastly, impaired capacity to regulate empathic arousal as evidenced by lack of empathy for or intolerance of expressions of distress of others, or excessive responsiveness to the distress of others. Next slide, please, George. So, and then post-traumatic symptoms, spectrum symptoms, the child exhibits at least one symptom of at least 2 of the 3 PTSD symptom clusters in B, C, or D criteria that we've been going through. And then F is the duration of disturbance of symptoms in criteria B, C, D, and E for at least 6 months. And then lastly, of the DDT criteria, developmental trauma disorder criteria, would be functional impairment. So in at least 2 of the following areas of functioning, there is impairment: scholastic, familial, peer group, legal, and health. And as you all will be receiving these slides after the presentation, I'll leave you to take a closer look at all of that information. You can carry on to the next slide, please, George. I just wanted to spend a bit of time, as I said, thinking about developmental trauma disorder, because it is a very common presentation in children under special guardianship, particularly where orders were made in the context where the special guardianship order was granted in the context of care proceedings, or where the child was looked after. So just to highlight some resources on the back of our conversation about the impact on children of enduring parental maltreatment. As I mentioned, Bissell A. van der Kolk, who developed the clinical diagnosis of developmental trauma disorder. And he has written what has now become a very famous book back in 2014. He's written a lot of scholastic work, but this was one that entered sort of the wider public domain as an area of great interest. It's quite straightforward reading. It's very dense with The Body Keeps the Score. Some of you may have heard of. It's a very dense book full of extensive clinical research, absolutely fascinating. Dan Siegel spends a lot of time researching the neurobiology of interpersonal relationships. There are fantastic presentations that he's given that are available for free on YouTube. Dan Hughes and Kim Golding have done a lot of work, again, a lot available on YouTube, around therapeutic parenting, which is a specific parenting model for children with developmental trauma. It's distinctly different from standard or traditional parenting. There is some overlap, but it is different. And therapeutic parenting model uses something called PACE, which stands for Patience, Acceptance, Curiosity, and Empathy. So the Centre of Excellence in Child Trauma is a UK organisation. It's an umbrella organisation of many sub-organisations, one of which is the National Association of Therapeutic Parents, NATP, and they have free resources available. They've got a fantastic podcast series, and then they have an inexpensive or a nominal membership fee for adopters, special guardians, foster carers, schools, and other supporting professionals. And then Beacon House, some of you may have heard of. It's a specialist trauma clinic. It's based in Chichester. They've got a couple of locations down on the south coast. And they have an excellent resource section on their website for carers and professionals that I would encourage you to take a look at. Next slide, please, George. So then just moving on to thinking about post-order support in terms of the rights of special guardians and children under special guardianship and the duties of the local authority. So a post-order support plan is drawn up within the SGO assessment that I discussed earlier, and it's agreed by the court when the SGO is granted. The post-order support plan outlines the parent-child contact principles, support available via universal services, and support to be delivered by the local authority. For instance, the fortnightly allowance payments, and that is subject to eligibility determined by an annual means tested assessment after the first 2 years of the capped allowance. Letterbox contact, the local authority supervised parent-child contact in special circumstances. That is something that we organise and look after. We keep that under review, and I'll talk a bit more about that when I come on to the family and friends team and the specific support that we provide. And then within a post-order support plan, there is also mention of the Adoption Support Fund, which I will talk a bit more about later. So all special guardians have a statutory right to request that the local authority review the post-order support plan. That can be at any time throughout the life of the order, throughout the minority of the child. It can be once or as many times as the local authority, as the special guardian requests that the plan be reviewed. The local authority has the duty to offer an annual review of the post-order support plan, and the local authority has a duty to complete a post-order needs assessment if a child was previously looked after and a special guardian is seeking support for the child, or if a child comes to us seeking support, perhaps a 17, 18-year-old child. So post-order support is accessed by special guardian, self-referral, or by professional referral. George, please move on to the next slide. So local authority responsibility for post-order support. There are some differentiations between PLAC and non-PLAC children, previously looked after children, and these are distinguished within the SGO regulations. So for non-previously looked after children, post-order support is the responsibility of the local authority in which the special guardian resides. So if the special guardian moves, if the order originated in Surrey and the special guardian moves to another authority, it's the new authority they've moved to that would be responsible for delivering post-order support. Or if at any point in the life of the order that the special guardian were to move, then at which time support is sought, they would need to seek that from the authority in which they live. So local authority to local authority case transfer under post-order case transfer is not necessarily automatic. It would occur if there is an active delivery of post-order support following the SGO being granted, and there would be a transfer. However, we do have a number of special guardians who don't seek to have active local authorities post-order support after the order is granted. They might not come seeking support until months or years after the order has been granted. So in that instance, then the authority in which they live, they need to approach, and that authority would then come to Surrey seeking some case history to enable them to have a better context for the family's needs. And then for previously looked after children, post-order support is the responsibility of the originating local authority, so in this instance Surrey, for the first 3 years after the order is granted. And then if the special guardian were to live outside of Surrey, then post-order support is transferred to that authority in which the guardian lives. Or if any time during the life of the order, the special guardian were to move to another local authority, an OLA, then post-order support becomes the responsibility of that local authority, and that the special guardian would need to seek support from that other local authority in which they've moved to. So post-order support is accessed by special guardian self-referral or professional referral, and that is irrespective of whether the child was previously looked after or not. So next slide, please, George. Lovely, thank you. So Surrey has a referral pathway to post-order support, depends upon how the SGO is made. So every local authority can determine for itself what their post-order support delivery service looks like. So Surrey has devised its own approach, which is as follows. And this is my reason for having earlier gone through how special guardianship orders come about, because it links to this post-order support. So if the special guardianship order was made at the conclusion of care proceedings or immediately following a looked after episode, then the family and friends team the post-order support service, is responsible for delivering post-order support, and we are the ones that the special guardian or referring professional would come to. Our contact details are there. Again, you'll get the slides after the presentation. Quite straightforward. Email address sgo.postordersupport@surreycc.gov.uk. If the special guardianship order were to have been made outside of care proceedings, or the child was not looked after immediately before the special guardianship order was granted, then it's Children's Services who are responsible for delivering post-order support, and the referral pathway would be via the main referral pathway. When referring a child to Children's Services would be request for help, the children's single point of access. I've highlighted the word immediately where I say the child was not looked after immediately before the SGO, because that makes a difference. Some children might have been looked after at some point before the SGO was made, but there's been a period of time where the child was not looked after, perhaps returned to parental care or another private care arrangement, and then sometime after there was a special guardianship order granted. And in order for support to be provided, there needs to, by the family and friends team or Children's Services, there would need to have been that status of immediately before the order was granted, that the child had that looked after period. And that makes a difference when I talk a bit later about the Adoption Support Fund, when the child was looked after and whether that was immediately before the SGO was made. And then in any occasion where there are safeguarding concerns about an SGO child, that would be a referral to CSPA. The Family and Friends team does not deal with safeguarding matters, so you would treat the SGO child like any other child that you were referring to Children's Services due to safeguarding related concerns. And then under child arrangements orders, post-order support is always the responsibility of Children's Services to assess. So the Family and Friends team does not provide any support post-order to children under child arrangements orders. Next slide, please, George. So thinking a bit about the scope of support that we do offer special guardians and SGO children under the Family and Friends remit. So general advice and guidance, that's a very common one. We undertake post-order needs assessments. And the Adoption Support Fund I've mentioned a couple of times. So this is a central government pot of money, a DFE pot of money for specialist therapeutic interventions, specifically for trauma and or attachment difficulties that the child is assessed to have. The ASF has very clear criteria, which is that the child must have been previously looked after immediately before the SGO is granted. The funding is available up to the age of 21. However, if the child has EHCP, then their eligibility is up to the age of 25. And then we commission the private therapeutic clinicians, and we try and arrange these commission providers that are local to where the family live. So the Adoption Support Fund is accessed via the Family and Friends team, and we assess through a post-order needs assessment. We assess the needs of the child relating to their therapeutic needs, and then make arrangements once the funding has been secured from the Adoption Support Fund for that local therapeutic provider to work with the family. Parent and child contact is another area that we provide a lot of support around, particularly advice and guidance, because it can become quite a tricky road to navigate for some special guardians, where parents would like to see contact occur on their terms, and the special guardian assesses the child's needs looking different to those that the parent perceives the child's needs to be, or their own needs to be as the parent. So short-term local authority supervised contact is something that we do arrange. That is when we have assessed that there are some live safeguarding risks that the parent poses that would not be manageable by the special guardian. For instance, if the parent is experiencing a more acute mental health crisis, we do risk assess whether or not we will implement local authority supervised contact. It's not something that is universal or automatic, so it is subject to risk assessment by our team, and we keep it under review at least every 3 months, but often more often than 3 months, to ensure that it is it's an essential service, bearing in mind that there is a cost implication to it. Kinship Connected is one of our support schemes. We have commissioned this through an SGO specialist charity called Kinship, and we are responsible for making the referrals to that scheme, and so it can be accessed via ourselves, and special guardians, of course, can be signposted to us if they want to know more about that. Informal mediation or family meeting facilitation is something that we provide. Very often this can be around contact disagreements between the special guardian and parents, but any matter that is arising in which we deem would be appropriate for informal mediation or an informal family meeting to take place. We offer this in a hope that it will preempt the need for there to be a more formal process within the court arena. Many families do take us up on this. Some parents opt to seek to put the matter straight before the court. But as I said, we do emphasize this as being a very useful approach to trying to navigate the complexities of parent-child contact. Letterbox contact administration, we do have some instances where the details, the postal details of the special guardian are strictly confidential, which therefore make it quite difficult for a parent to perhaps send parcels through for the child. So we facilitate that letterbox contact. George, next slide, please. Right, so finance is another area of support. I'd mentioned earlier about the SGO allowance, so we look at eligibility. If, for instance, at any point a special guardian is ineligible because they don't meet the means tested assessment criteria, and their circumstances, their financial circumstances change during the life of the order, they can come back to us and seek a fresh financial assessment. And I will just note here that when I talked earlier about transfers of post-order support to other local authorities if the special guardian moves, the only area of post-order support that doesn't move to the other local authority is financial responsibility. That always remains with the local authority in which the special guardianship order was granted. We provide signposting and referrals, post-order support plan reviews, which I mentioned earlier. At any point that a special guardian would like to have their plan reviewed, they can approach us and we will undertake that with them. Letters of support, for instance, housing related or confirming where a child had been previously looked after. We have had some instances where special guardians sought to have their child receive pupil premium grant in school, and schools queried whether in fact that was even possible. So we have written letters of support to state that the child, yes, indeed was previously looked after and under the guidance are eligible for pupil premium grant. And I know that Ellie will talk a bit more about that in a little bit. We do provide support groups for special guardians, not for the children under special guardianship order, but for special guardians. Those are virtual, and from May of this year, they will be, well, resume face-to-face. We've had to suspend those during the COVID pandemic. And in order for a special guardian to be put onto our mailing list to find out about support groups, they do need to come to us and make that request, and that has to do with GDPR and data protection. So court orders and private proceedings, after a special guardianship order is made, we provide information to the court where a parent has made an application for the court to relook at contact arrangements. Often the court would like to have an account of what our involvement has been, if we have been involved in helping negotiate contact arrangements through informal negotiation with the family. And where special guardians are requiring a copy of their special guardianship order, they can approach us to obtain that. We provide historical information to other local authorities and professionals who get in touch with us seeking to know a bit more about how they can support the family. Within the limits of data protection, we're able to provide some information, and so the main instance in which we provide historical information is when another local authority is completing the ASF, the Adoption Support Funding application for a Surrey originating child. And within those applications, there does need to be quite a historical case information provided. So we pass that over to the authority that's completing that application if the family's moved outside of Surrey. We do provide membership to special guardians who are eligible for post-order support from the family and friends team, that membership to the NATP. Again, that's by a request, it's not automatic. We do provide advice to supporting professionals like yourselves. We do actually have quite a number of calls that come through from education professionals where they've got an SGO child, they're not quite sure what special guardianship is all about, which is part of what's brought about this workshop, or they're not sure what the child is entitled to or the special guardian is entitled to in the way of support. And so you can feel free to call us to find out, or to email us to find out whether the child is eligible for support from the family and friends team, or if that support needs to be sought through the main front door through request for help. Very often we find that special guardians themselves, particularly if it's been a number of years since the order was made, can't quite recall the detail of whether the order was made in care proceedings or outside of care proceedings, and therefore we can look on our system and ascertain whether in fact the child is eligible for support from the family and friends team or meets the criteria where they would need to seek support from children's services. We do participate in early help under TAF, also child need and networking meetings. So where children are open under those remits, then we will participate in that process so that we work in a joined up way with other involved professionals or agencies. And then lastly, we certainly are involved with any transfers of SGO children in or out of the authority. So next slide, please, George. Right, so just to say that the way we work is that we don't case hold, so we don't operate in the way that children's services do, where children have an allocated social worker. So with us, children don't have an allocated social worker. If they happen to be open to children's services, we do have some children where the SGO is made, children's services closed the case, there's been a passage of time, whether that be months or many years, and then there's been a fresh referral in for children's services or to the CSPA, and that has led to children's services opening the child perhaps under child in need. And so in that case, there would be an allocated social worker, but we do not allocate under the post-order remit within family and friends. We are a self-referral service, which I've mentioned a few times, but I'm stressing that because so many special guardians seem to be unaware of that, even though it's spelled out within their post-order support plan. And we endeavour to have a consistent point of contact between myself and my colleague, Marcia Neat, who works alongside me. So we generally split the county east-west where possible, so that special guardians have that main point of contact. So as I said, we don't case hold, but we work in a way where special guardians have some continuity and consistency. Next slide, please. George, lovely. So there are some universal resources for special guardians and for primary caregivers named within a child arrangements order. Those include Kinship Charity, that was previously called Grandparents Plus. They sort of repackaged themselves about a year ago and renamed themselves Kinship. They are a SGO and Kinship specialist charity. They are the charity that we commission a more enhanced scheme through, but they do have universal advice line for special guardians and kinship carers, and also for professionals in schools. And they also offer a peer-to-peer support scheme, and that's a universal scheme, so that does not require a referral from us. The CAMS has a post-order specialist service for SGO and adopted children, and that's accessible via the main CAMS referral pathway, and that can be by family self-referral or a professional referral, and then the family rights group. Next slide, please, George. Right. So just a bit about child arrangements orders. I did mention at the start that this is not my bread and butter, but also there's really not an awful lot to say because the provision, the regulatory provision for and legal provision for child arrangements orders is much more limited than for special guardianship orders. As I said earlier on, special guardianship orders are sort of a middle ground between a child arrangements order and adoption order. And so there are much greater responsibilities or duties placed upon local authorities than exists for child arrangements orders. So a child arrangements order expires when the child turns age 16, apart from when the order specifically names the residence of the child, so names who the primary caregiver of the child should be, a non-parent primary caregiver in most instances. And in that case, the order expires at age 18. In a child arrangements order, sort of that it's a contact order outlining the parent-child contact arrangements. Those arrangements might be very broad brush in general, or they can be extremely detailed. The local authority has the autonomy to decide whether or not to provide a plan of practical or financial support under a child arrangements order, as distinctly different from a special guardianship order where the local authority must prepare a post-order support plan that forms part of the special guardianship assessment that is considered by the court before granting an SGO. And I might just comment here that SGOs are not automatically granted just because a special guardianship assessment is being undertaken. If that assessment is a negative recommendation, then that will have implications potentially for whether the court will grant the order. The parental responsibility of the primary carer named in a child arrangements order is equal to the parental responsibility of the parent. Again, this is distinctly different from special guardianship, where the parental responsibility of the special guardian is dominant over that of the parent, the birth parent. So as from this month, children under child arrangements orders, a residence order, part of a child arrangements order, where their residence is specifically named within the order and it's not solely focusing on contact arrangements, are now eligible to access funding from the Adoption Support Fund. It's sort of hot off the press. However, the same principle or criteria applies as with special guardian children, which is that the child must have been looked after immediately before the child arrangements order was made. And I'll just note here that child arrangements order were much more widely used by the court before special guardianship orders came into effect in 2005. They are less frequent now, and most of the ones that we see relate to or were made many years ago, or they were made by the court in private family law proceedings where the local authority wasn't involved in any which way, where Children's Services wasn't involved, nor was the child looked after. And in those instances, we don't even know that they exist because we weren't involved. So for child arrangements order, as I've previously mentioned, the referral is via the CSFA. Next slide, please. Right, we're on to Ellie now. Thanks very much. Oh, we can't hear you.
I think I should learn that better. So for those who have just joined or joined halfway through, my name is Ellie Bissell and I'm the Education Support Officer for previously looked after children with Surrey Virtual School. And I'm going to talk a little bit about the virtual school's role in supporting previously looked after children. So next slide, please, George. So many of you may know the virtual school, but our service has expanded quite dramatically over the last couple of years with different remits. So we have our currently looked after children remit, where we case hold with our post-16 currently looked after and our UASC. And then in 2018, we were given the extended remit for previously looked after children, which I'm going to go a little bit more in detail in my next slide. And then our most recent remit is for children with a social worker, which was, I think, September 2021. But I'm going to talk about the previously looked after children. So next slide, please, George. So when we talk about the previously looked after cohort in relation to Surrey Virtual School, our service is based around the Department of Education's definition around this cohort, and that is that they define this group of children as those who are no longer looked after by a local authority in England and Wales because they have been subject of adoption, special guardianship or child arrangement order. It's important to point this out because when I talk about pupil premium later on, this does impact whether they are entitled to that funding or not. And I've just put a little asterisk at the bottom because we have come into instances where schools are not aware if a child comes under this cohort. So it's just to point out that children that are subject to these orders and they haven't left care through the order, so it may be that they became subject to the order to avoid coming into care, or the local authority wasn't involved, and children who have left care and returned home to parents don't come under this cohort, this PLAC cohort. So it's just important to point them out. What I would say is if you do have a child in your school where they do come under these kind of exceptions and you are looking for support, do contact myself or the virtual school inbox and we will try to signpost you to where you can get support and guidance. Next slide, please, George. So looking at the role of the virtual school for previously looked after children, because our remit is slightly different for our looked after children, and that's because we are no longer the corporate parent to this cohort. So our role is to promote their educational achievement, and that is through information and advice. And this duty relates to previously looked after children who are educated in the area served by the virtual school. So we cover all Surrey schools and all previously looked after children in them schools. If you have a child that is living in Surrey but is educated in Hampshire, it'll be Hampshire Virtual School that would work with their school for support. So each virtual school can decide the extent of their offer for previously looked after children, but at a minimum, virtual schools must respond to parental and guardian requests for advice and information. So that could be anything on advising schools, advising on school admissions, and where appropriate, signposting parents to other services and resources. We also are responsible for responding to requests from information and advice from schools, early education providers, alternative provisions, and that can be general requests for advice or in respect to individual children. And then finally, we must provide general advice and information to schools to improve the awareness of vulnerability and the needs of previously looked after children. and this is to promote good practice on identifying and meeting their needs, and also to guide on the effective use of Pupil Premium Plus. So this remit runs through early years right up until post-16. And I point this out that this is our remit and that we don't case hold because we are no longer corporate parents to this group of children, and we no longer are required to monitor their progress and achievement or held to account for their educational achievement. So our role is slightly different once they leave care. Next slide, please, George. So each virtual school will be able to offer a slightly different support offer depending on their capacity and the structure of the virtual school. At Surrey, we're lucky that we have an education support officer, myself, who works county-wide, which means that we can offer additional aspects to the core offer. So that means that I can attend meetings regarding previously looked after children to provide information and advice. So if you have a child who may be at risk of exclusion or is receiving lots of fixed term exclusions and you'd like us to be involved in meetings with other professionals to look at what support can be provided, we can do that. We can attend coffee mornings or information events at schools for parents and guardians to make them aware of what support is available in Surrey. We provide training such as this to DTs and school staff with other services to make you aware of what is available in Surrey and also to promote good practice in terms of meeting the needs of these children. We also have an EPLAC, which is an education plan for looked after children, or previously looked after children, and I'm going to talk a little bit more about that in a couple of slides' time. We also have our website, which has additional information and advice documents on there. So there's information on our role, on Pupil Premium. So it's a good place to start if you're looking for general advice. And finally, we offer appointments, PAC appointments, which is post-adoption CAMS and schools, which is a service provided by the post-adoption team. And we provide appointments for parents. It's third Thursday of every month, and they can book through the adoption team. And it's a chance for parents to sit down with CAMS or the EP service or the post-adoption support worker, and to schools also can attend, and it's to look at if there's any concerns and to look at next steps and to talk through what support may be available and what resources are available. Next slide, please, George. So I wanted to touch on Pupil Premium Plus funding, because in the last year or so there's been some changes and adaptations to the guidance, which I wanted to just make you aware of. So Pupil Premium was introduced in 2014, and that's because it was a recognition that children who ceased to be looked after often required extra support and help in school in the view of their early life experiences. And looking at the eligibility, so as I mentioned with the Department of Education's definition around previously looked after children, it's really important to know that they have to have been looked after and have left care through adoption or special guardianship order in order to be eligible for this funding. So the funding is available for statutory school-aged children, so it's from reception to the last term of year 11 to state schools in England. Children who have who attend independent schools or are home educated may be eligible, but their education must be funded by the local authority. So this academic year, the funding is £2,410 per year per eligible pupil, and this is paid directly to the school. In recent years, the way that schools claim the funding differed slightly. So originally it was through the January census, but from the last academic year, this has been changed to the October census, which means that it's giving schools less time in which to declare these children. So it's really important to make yourselves aware of these children. We do work with the adoption team and the friends and family team to send out a notification in September to make parents and guardians aware to declare their children's status to the school. But there also is a letter that we have a draft of that you can use to send out to just help identify any children that you may not be aware of. It's really important that you do declare them on the October census, as pupil premium can't be claimed in retrospect. Next slide, please, George. Just also to point out some changes in the guidance. So there's a new guidance that was published in March this year, and it just pointed out the key aspects of the designated teacher role in terms of pupil premium. And it points out that designated teachers should ensure that parents and guardians are aware that they can declare their child eligible for pupil premium, and also work with them to decide how the funding should be used. So at the virtual school, we do consider this best practice to work with parents and guardians to have conversations around pupil premium plus spending and how to use it. You can also consult us at the virtual school to help have these conversations, or to attend these meetings if you would prefer. And also the designated teacher is the main contact for parents and guardians on how pupil premium funding is being used to support pre-6 after children in schools. Next slide, please, George. And just to point out that as the pupil premium funding is sent straight to schools for pre-6 after children, we are not held to account for that allocation or the spend. However, we can provide information, advice and guidance around it to schools and parents and carers. And there is also lots of information on our website, understanding pupil premium, frequently asked questions for both schools and for parents and guardians, and then also links to all of the government guidance around pupil premium as well. Next slide. And then to quickly just talk about our education plan for pre-6 after children. So you may have come across other virtual schools having an EPLAC or an EPAC, and it runs similar to a PEP for a looked after child. However, it's not statutory. But again, we see this as good practice to have one in place, especially if there's a child in your school that may be struggling. So it's intended to be a working document to highlight the strengths and the needs of a child or young person, to create a targeted plan to enhance their education and identify good use of pupil premium funding. So we found that it's really helpful to use the plan times of transition or change. So at the end of the school year, planning for transition to the next school or the next year group. To record meetings with parents and carers. If you're having a lot of meetings or regular meetings with parents and carers, it's a great way to record them. To record pupil premium spend, if you're spending specific amount of money on a child for certain interventions, it's a great way to track that. Track progress and effectiveness of interventions. It's a good way to plan for support for a child that may be at risk of exclusion. And then also just to record ongoing support for a child or young person that may need that. It's just to say that obviously, as it's not a statutory document, we at the virtual school don't need to retain a copy of it. However, if you do need to advise us to advise on how to use it or when it may be appropriate to implement one, we can do that. We are in the process of getting the plan up onto our website, but for now, if you would like a copy of it or to chat through more about using one in your school, please do contact me and I can send that over to you. Next slide, please, George. It's just to point out, so on our website, if you go to young people and then under there is previously looked after children, and we have lots of information on our role, People Premium, and also we'll have our education plan information there as well. So it's a great source for general advice and guidance, and also has lots and lots of information and links to other resources as well. Next slide, please, George. And then is to mention our training sessions. So we provide training during the academic year, and our training can be found on our More tab and then under training and events. And also we record a lot of our training, and then it is uploaded onto our YouTube channel. So if you miss any training or you want to see previous training sessions, you can go on there, and they'll all be there for you. Next slide, please. Next slide, please. And that is the end. So, do you mind putting the slide back up, George? So there is mine and Catherine's contact information, and also the virtual school inbox and the friends and family team referral email as well, should you need to contact us. But if there's any questions, you can put them in the chat. I'll also enable people to unmute. Yes, Mrs. Power.
Hi, can you hear me?
Yes.
Hi. So I'm just going back through my notes and looking at, so you have a looked after child, which I'm familiar with that. And then if you're no longer looked after, you become a post looked after. But are you saying that there are 3 categories of post looked after, one being adoption, one being special guardianship order, and one being the CAO, child arrangement order? So do those kind of 3 areas basically come under the generic title of post-LAC?
Yes, so in terms of looking at the Department of Education, what they class, that's who they class within that cohort. So it'll be children on who have left care through adoption, child arrangement order, or special guardianship.
Okay, but so the umbrella term for all those 3 groups of children is post-LAC, is that right?
Yes, post-LAC, previously looked after, they're the terms that we use.
So sorry if I'm not being clear. So if you're now an adopted child, that you also referred to as a post looked after.
Yes.
Yeah. Okay. Thank you.
That's right.
I might just comment quickly to say that not necessarily all children under special guardianship or child arrangements order, or even adopted for that matter, might have been looked after before the order is made, but the vast majority of them have been.
Okay, so if they weren't obviously looked after, then they're not post looked after. Yeah.
No, in terms of provision, accessing support from the virtual school, but just in a more broad sense, I just wanted to make that comment, because you might certainly have children who are under special guardianship who would still be eligible for support services being under special guardianship, separate from previously looked after services.
Okay, thank you.
Just that distinction to make.
Yeah, great, thanks.
Any more questions?
Guess we covered it all, Ellie. Everything there is to say.
If you do have any more questions, please do feel free to email us. or email the virtual school inbox and we can make sure that they're forwarded on to the right person. Christine, Miss Power, I will send you the copy of the e-plaque, and if anyone else wants a copy of it, please do email me and I'll happily send it over to you. And Miss Knight. And I will just pop the feedback form into the chat. If you could fill it out, that would be great, so we can have some feedback. And Rebecca Stacey as well. But I think that's it then. Our recording.